Are you aware of the changes to the Immigration Act 2016 that came into force in April 2022? The Immigration Act is a piece of legislation that is applicable to landlords and letting agents and came into force in England on the 1st of February 2016. The legislation states that a landlord and/or a letting agent must be able to evidence any occupier's right to reside within the property throughout the duration of the tenancy. This means that prior to a commencement of tenancy, a landlord must check that any tenant or occupier that is going to be living within the property has the right to rent in the UK. This is applicable to every adult 18 and over that will be living within the property, whether named on the tenancy or not. It is very important that discrimination does not come into play when verifying a tenant or occupier's right to rent, and you must ensure that you are treating every applicant in the same manner and asking them to provide the same evidence that they have the right to reside. The easiest document to use to prove your right to reside in the UK would be a passport. If it is a UK passport, this is sufficient right to rent evidence for the duration of your tenancy. If your tenant is from the EU, their right to rent can now be verified online. In order to do this, you need to obtain a share code given to you by the tenant or the occupier, and you will use the share code along with their date of birth and full name to conduct an online right to rent check, and the link to do so will be in the description below. If your tenant or the occupier is from outside of the EU or the UK, then other documentation will be required to verify their right to reside. This is normally in the format of a passport with a supporting visa, showing the entry date that the tenant or the occupier entered the UK and the expiry date as to which their visa will expire. It is important to note that anybody, tenant or occupier, that has a limited time to remain. What do I mean by that? I mean a visa with an expiry date or a specific time frame that they are allowed to reside in the UK, then you will have to conduct a follow-up check. The follow-up check will need to be carried out either upon expiry of the visa or 12 months after you carried out the initial check, whichever is the later. So this actually means that you could, in theory, legally move a tenant into a property today and their visa expire tomorrow. You would not be breaking the law by doing this, but as a landlord you may want to consider other issues that may arise should their visa not be renewed throughout the duration of the tenancy. It may mean that your tenant needs to return to their country of origin during the tenancy and therefore not able to fulfil the fixed term. It is important that landlords keep documentation and evidence that the right to rent checks were carried out upon the initial start of the tenancy, and also any subsequent follow-up checks that are conducted whilst the tenant remains in situ. Now landlords, I have mentioned a lot the word occupiers. This means that not only are you responsible for verifying the right to rent in the UK of your tenants, which is quite easy and straightforward because you know who they are, you also have a responsibility in terms of occupiers. This means that you should regularly inspect your property to ensure that the people living within the property are the known tenants and you are not in a situation where you have unauthorised occupiers that haven't had their right to rent verified. If you're finding this video useful, please subscribe to our channel for more videos on compliance in the private rented sector. All documentation should be seen in person and the original document provided to you. It is important that this is carried out face to face as per the requirements of the Act from 2016. However, due to recent events, for the past 2 years, we have been able to conduct adjusted right to rent checks. This means that we have been able to conduct checks via video call with the applicant and a picture of their documentation to verify they are who they are. This amendment has now been extended to the 30th of September 2022. On the 6th of April 2022, further amendments were made to the Act in the form of biometric residence permits. These are documentation that we have for many years now used as evidence of a person's right to reside in the UK. A biometric residence permit can be for anybody from any country that has a set amount of time to reside. These, unfortunately, alone are no longer evidence of your tenant or your occupier's right to rent, and further checks must be conducted. As we mentioned earlier in the video, EU nationals now have a facility online whereby they can grant you with a share code for them to verify their right to reside in the UK to you as a landlord. Biometric residence permit holders can now do the same. So if you have a tenant or an occupier that is to provide you with a biometric residence permit as proof of their right to reside, you must now also ask them for a share code, their date of birth, and of course their full name to allow you to conduct the full online check to ensure that your tenant or occupier complies and meets the requirements. Landlords, I know we are not immigration officers, and in some cases it may seem unfair that this burden is passed down to you. However, it is a very, very important piece of legislation for you to comply with, because it does carry penalties of up to £3,000 per occupier and or a prison sentence. The Immigration Act 2016 is just one piece of legislation in our private rented sector. I do host a quarterly webinar for landlords just like you, sharing information on all of the other bits of legislation that you need to comply with. This is held quarterly and you can attend free by clicking the link in the description below. If you want to learn more now, we have a playlist dedicated to compliance for landlords in the private rented sector, and you can view more videos by clicking here now.